everybody. Welcome to today's webinar. We're really excited to have you all joining us from different places of the world. And we just want to welcome you today to the Water in the International Court of Justice webinar with recent developments. This event is co-hosted by IWRA, the Geneva Water Hub, and also AIDA. Again, thank you for joining us today. IWRA is an international network of water researchers, of practitioners who work on a multidisciplinary range of water resources issue. The platform provides a global knowledge-based forum for bridging disciplines and geographies, and by connecting professionals, students, individuals, corporations, and institutions who are concerned with the sustainable use of our world's water. For today's discussion, our panelists include Gabriel Eckstein, Professor of Law and Director of Energy, Environmental, and Natural Resources Law Program at Texas A&M University, Dr. Laura Movilla, who is a lecturer in Public International Law at the University of Vigo, Richard Paisley, who's the Director of the Global Transboundary International Waters Governance Research Initiative at the University of British Columbia. We also have Salman Salman, who is the World Bank former lead counsel and water law advisor. Also joining us is Dr. Mara Tigneal, reader at the Faculty of Law of the University of Geneva, lead legal specialist of the Platform for International Water Law at the Geneva Water Hub. As we delve into today's discussion, it is important to note that the International Court of Justice has heard very few cases involving international water law, but the number of water-related cases has risen as water conflict increases. This webinar will examine the most recent ICJ dispute between Bolivia and Chile, as well as the content and relevance of all the ICJ water-related judgments. Today's webinar will be split up into two discussion sequences. The first will be to provide background information and context to the Salala case. And in the second part, speakers will be placing the decisions around the Salala case around the wider international water law context. Each discussion sequence will last about 20 to 25 minutes. And after each discussion sequence, we will provide answers to the audience's questions. So please make sure that you put your questions in the Q&A box. Feel free to comment in the chat, but your Q&As for the panelists, please put them in the Q&A box. And with that in mind, I would like to turn the floor over to our moderator, Christina Leb, who's the Senior Counsel at the World Bank and Fellow at the Platform for International Water Law. Over to you, Christina.
Thank you, Lindsay, and hello, everyone. Good morning, good evening. I see everybody's connecting from across the globe. It's great to have everyone here. Lindsay already sort of went through the program. We will be discussing first the case, the most recent case, the International Court of Justice decided on between Chile and Bolivia on the Silala. And we have with us, as Lindsay said, a great group of experts comprised of both agents and team members of teams that have worked with the two parties on the case, as well as international renowned water law experts who will be commenting on the role of the case, on the role of the International Court of Justice, its general, more general implications for international water law, of its decisions, the identification of customary rules and principles of international water law. So it's gonna be an exciting discussion. I just wanted to remind everybody that everyone who speaks here today is doing so in his personal capacity, his or her personal capacity. We're not speaking for our institutions. We're not speaking on behalf of the parties that our speakers might have presented during the case that we're discussing or other cases. So just be aware we're all speaking in our personal capacity. And without much ado, I want to hand it over to Laura, who will introduce the case to us, and then Gabriel and Mara will discuss the positions of the parties. So diving into the first part of our discussions, also note that after this part, we'll have a short Q&A to see if any questions have come in. As Lindsay mentioned, please put them into the Q&A part of the Zoom functions. We will not be monitoring the chat for questions. And then in the second part, we'll also have a more open discussions after the panel discussions. So we hope for a very interactive session, and over to you, Laura, to introduce the case to us. Thank you very much.
Thank you so much, Christina. Hello, everybody. Let me just share my screen here. Okay. So thank you so much to IWRA, AIDA, and the Geneva Water Hub for this opportunity to participate in this webinar on such an interesting topic and with such distinguished speakers. So before starting the discussion, let me introduce very briefly the background of the case. So what is the Silala? The Silala is a small watercourse that it's located in the border between Bolivia and Chile. You have there a map that was included in judgment, and you can see the area that it's an arid area. In fact, it's surrounding the Atacama Desert. And regarding the diplomatic political background of the relationships between the parties, that it's very relevant. It's worth highlighting that the two countries do not have diplomatic relations since 1978. They only have them at consular level. And there's a deep history of tensions between them in general. In fact, this is not the first case that they bring to the ICJ. Already in 2018, the court decided on the obligation to negotiate access to the Pacific Ocean that was related to Bolivia's claim to sovereign access to the Pacific Ocean after having lost its coastal territory during that war at the end of the 19th century. And in that first case, Bolivia was the claimant, and it has a negative result before the court for Bolivia. And if we see, if we look at the features of this watercourse more in detail, it has its source in Bolivia, specifically in groundwater springs in high altitude wetlands known as bofedales that are located near the border with Chile in the Potosí department of Bolivia. And following the natural topographic gradient of the terrain, which slopes from Bolivia towards Chile, the flow of the Silala, both surface and groundwater, crosses the boundary towards Chile. But also, most of the groundwater springs located in Bolivia has been drained through small artificial canals into two main canals that you can see there in the picture of the left, the North Canal and the South Canal, that also converts in a main canal that crosses the border towards Chile. In fact, if we go back to the previous map, you can see that after the boundary, the Silala River continues to flow southwest in the Antofagasta region of Chile until it discharges its waters in the San Pedro River at about 6 kilometers from the border. And those canals that I've mentioned before, those canalization works in Bolivia have their origin in a concession of the waters from the Silala made by the Bolivian Department of Potosí in 1908 to a British railway company that was operating in Chile and that wanted the water to feed the steam engines. But when those engines were replaced by diesel engines, the water was allegedly used for other purposes, not including in the concession. That's something for which Bolivia has claimed compensation. And in more recent years, especially in the period up to 2010, both countries have attempted to reach an agreement on the management of the Silala. They have even created a joint working group to carry out scientific and technical studies on the Silala. And they even drawn up two draft agreements in 2009, but they were never signed. And after more tensions between the parties in 2016, Chile decided to request the initiation of proceedings on the status and use of the Silala waters against Bolivia before the ICJ. After the written proceedings and the oral proceedings, the court finally issued its judgment on the 1st of December of 2022. Very briefly, in relation to the merits of the case, Chile has always considered the Silala to be an international watercourse, but Bolivia started the proceedings considering that the Silala were domestic springs from which the water was diverted artificially by those canalization works downstream to Chile. However, all the scientific studies that Bolivia requested commissioned during these proceedings revealed that the waters of the Silala will have flowed anyway in the border into Chile, even without that canalization. So the position of the two parties eventually converged during the proceedings. So at the end of them, basically the points of these agreements were two: the effect of that artificial infrastructure on the surface flow of the Silala, and the alleged breach by Bolivia of procedural obligations of notification and consultation. And regarding the science of the case, both parties accompany their written submissions with the reports from their experts. They were quite lengthy reports from their scientific experts on the nature of the Silala, on the impact of that canalization on the flow, and so forth. And during the oral proceedings, those experts were also examined and cross-examined. And both Gabriel Eckstein and Mara are going to have more time afterwards to explain a little bit more about the claims of the parties, but let me just introduce the final submission of the parties at the end of the proceedings very briefly. So Chile's final claims were that the Silala River was an international watercourse governed by customary international law, that it was entitled to its equitable and reasonable utilization and to its current use of those waters, that Bolivia has the obligation to take all appropriate measures to prevent harm and to provide Chile with timely notification of planned measures which may have an adverse effect on those waters, and that in fact Bolivia has already breached its obligations of consultation and notification in relation to some activities that were announced or carried out in the vicinity of the Silala. For its part, Bolivia basically emphasized that the surface flow of that international watercourse has been artificially enhanced. It also emphasized that both countries, both Chile and Bolivia, had all those rights and obligations established by customary international law, and denied having breached any obligation. And finally, regarding Bolivia's counterclaim, they were related to the sovereignty of Bolivia over the artificial canals in its territory and the right to decide whether and how to maintain them, that it also has sovereignty over the artificial enhanced flow in its territory, and that Chile has not an acquired right to it. And finally, that any request by Chile for the delivery of that enhanced flow, including a possible compensation, was subject to an agreement between them. And Chile basically rejected all those counterclaims of Bolivia. So I think Gabriel and Mara are going to dig deeper on these claims of the parties. Thank you so much.
Thank you, Laura, for presenting the case to everyone, and I'll hand it over directly to Mara and Gabriel Eckstein, who both worked on the case directly, and to give us sort of the legal arguments of Bolivia and Chile, and then we'll hear from Laura again the decisions, and then we'll hear back from Mara and Gabriel how the decisions actually picked up the arguments of the parties. So over to you, and I think Mara, you will start, correct? Yeah.
Thank you. Many thanks for organizing this webinar together. We are honored at the Geneva Water Hub to organize this webinar with IWRA and AIDA. Again, I would like to say that I'm participating in my own capacity. I've been a former counsel of the Republic of Chile in the Silala case. So just to share some preliminary remarks, I would like to mention that in this case, it is one of the few cases where we do not have an agreement on the waters of this international water course, the Silala. So this is a difference compared to other cases that were brought to the ICJ, and in particular, since the International Court of Justice had really not the opportunity to go into the customary law, that it was the only legal regime applicable to the Silala River. Then I would like also to mention that the two countries are not parties to the Global Water Convention, so the UN Watercourses Convention and the UNEC Water Convention. However, the two countries have relied heavily on the UN Watercourses Convention. And in particular, an issue at stake was the extent of customary international law reflected in the UN Watercourses Convention. So the two countries, Chile and Bolivia, had a different interpretation on the extent of the customary international law reflected in the UN Watercourses Convention. Also, a specific feature of the Silala case, it is the positions of the parties have evolved over the time, and in particular the position of Bolivia at the beginning, as also Laura already mentioned, the beginning was to deny that the Silala waters were an international water courses, but already in the counter memorial submitted during the written proceeding, it was recognized the international nature of the Silala waters. For this reason, this is already an important achievement for Chile to have this legal recognition of the international nature of the Silala. And so I would like to give a short overview about the four submissions submitted by Chile. So regarding the legal status of the Silala, we have already seen that there was this recognition by Chile about the international status, but one of the issues that it remains open, it is if the Article 2 of the UN Watercourses Convention that defines an international water course reflects custom international law. The International Court of Justice didn't give a specific answer to this question of the customary value of Article 2. The second point regards the principle of equitable and reasonable use. So in this regard, Chile made two claims. The first one, it was related to the entitlement to the equitable and reasonable use of the Silala River, and the second one, it was the entitlement of Chile to the current use of equitable reasonable use. And we can say that there was here again a convergence of the position of the two parties in recognizing the customary law reflected in Articles 5 and 6 of the UN Watercourses Convention. Then the claim D of Chile was related to the prevention and the control of harm resulting from the activities in the vicinity of the Silala River system. And here also the parties referred to Article 7 of the UN Watercourses Convention, but there was a disagreement about the threshold of significant transboundary harm, even if the court recognized then that the two parties, even if there was sometimes the reference to the transboundary harm, there was an agreement in this regard. The final submission of Chile was relating the obligation to notify and consult, and here there was the court did not recognize the customary nature of Articles 11 and 12. We will be able maybe to discuss later what are the implications of the lack of the recognition of the customary nature of these two articles. Thank you.
Thank you, Mara. Gabriel, I'll hand it over to you. Thanks.
Thank you. Thank you, Christina, and thank you, Mara, for that really spot on analysis. So I had the distinct honor of working with the Bolivian side and actually presenting part of its case before the International Court of Justice. And as Mara said, that the case started in very distinct points in terms of their interpretation of the physical aspect of the Salala, not just the law, but the physical aspect. And as Mara said, Bolivia started from the position that this was an entirely domestic water body that happened to flow artificially across the border. And that was one of the concerns that Bolivia had, was whether the Salala flowed across the border naturally because of the gradient, or was it merely because of the artificialization, the canalization that allowed it to cross the border? And of course, as Laura explained and Mara explained, after Bolivia had done the studies, they recognized that, as a physical matter, yes, the water would have flowed naturally across the border, but there was still a question, both as a physical matter and as a legal matter. The canalization, the fact that you're straightening out this water body, this creek that had meandered through the wetlands, the fact that you had drained the wetlands, which is effectively draining the groundwater, was that causing any kind of enhancement to the amount of water that was crossing the border? So in fact, you're taking water from the surrounding environment and from the groundwater that might have crossed over maybe 10, 20, 50, 100 years, and you've sped up that flow. And so Bolivia took the position that this was some form of enhancement of that water body crossing the border, and as a legal matter, wanted it to be recognized. Now, of course, the court declined to do so, but I wanted to just lay out sort of Bolivia's position on that, because I think there was a convergence, as Mara mentioned, in terms of how the two parties interpreted both the physical aspect of the Salala in terms of how they saw that this was in fact a transboundary watercourse, but also in terms of what law applied. So part of it relates to, you have an international watercourse, and an international watercourse is subject to the rules of equitable reasonable utilization and no harm and so on. But is it the entirety of the watercourse? Is it all the natural flow, or is there any aspect of that water that is artificially enhanced? Should that also be subject to the same rules? And that was Bolivia's position coming into the case. And we'll talk more about it, but the court effectively rejected. It's not necessarily that they rejected. They essentially said that the parties had come to an agreement on the status of the watercourse and the law that applies, that the court really didn't have to address or come out with any ruling on this. And they came up this, the no object decision on virtually every claim or counterclaim, and we'll talk more about that in a little bit. On the issue of significant harm and the potential that Bolivia's actions may have caused some kind of impact to Chile, I think that the point here that Mara was raising about the threshold, part of it is the threshold in the legal matter in terms of what kind of impact do you need to have to make the case actionable in court. And this is where the court got into the discussion of, the Article 11 in the Watercourses Convention was not part of customary international law, but Article 12 may have been part of customary international law. The other part, though, is facts on the ground. What kind of activities do you have to have on the ground that rise to the level of an action that can have potential impact? Because the idea is not that you have to have actual impact, but the threat of potential impact can trigger the notification obligations. And the question is, well, what kinds of actions? And in the case of Bolivia, there was they tried a fish farm for a short time. They had constructed some buildings in the very close vicinity to the Salala on the Bolivian side, but never actually occupied or used them. There's a small military garrison, a handful of soldiers that were placed right there. So the question is, do these actions actually rise to the level of some activity that had the potential to cause the cross-border effect to Chile, thereby triggering any kind of notification, a prior notification, and the court eventually said no, and we can talk more about that later. As regards notification, I think I already mentioned that the points about Article 11 and 12, as Mara did too. So I think I'll just stop here, and then maybe we'll leave more time for the discussion of the court's decision.
Thank you, Mara and Gabriel, for sort of outlining the arguments of the parties, where they sort of really started out at very opposite ends, and then sort of referring to the point that over the course of the proceedings there has been sort of some convergence. And Gabriel, also thank you very much for really mentioning sort of this question about groundwater surface water interactions and what happens when we modify flow speeds through interventions, and how do we actually interpret that in international water law. So Laura, over to you. Give us an overview of how actually the court evaluated these arguments, and then let's go back to Mara and Gabriel to really sort of discuss what that means for international water law. Thanks.
Thank you, Christina. Let me share my screen again. And you have there a summary of the judgment. And it was quite a short judgment, in fact. First, it's important to note, and this is something that Mara has already highlighted, that since there's no a specific treaty on this watercourse, and since neither state, neither Chile or Bolivia, was a party to the 1997 United Nations Watercourses Convention, the court decided the case based exclusively on international customary law. What did the court say? Well, regarding first the Chile's claims, the court, both Gabriel and Mara already advanced this, the court acknowledged that convergence of positions between the parties on most of the points of the dispute. So it considered that the 4 first claims of Chile were devoid of any object because of that convergence of positions of the parties during the proceedings. So the court declined to issue really a decision on those 4 points. However, regarding the 5th claim of Chile, the court unanimously rejected that claim that alleged breach by Bolivia of its obligation of notification and consultation regarding measures which may have an adverse effect on the watercourses, because the court considered that Chile failed to demonstrate any harm or even claim any harm caused by those activities, let alone significant harm, that is the threshold required by customary international law, according to the judgment. And regarding Bolivia's counterclaim, they receive a similar fate than Chile's claims. And the court ruled again that the parties have also reached some kind of agreement on some of those points. So the court considered that the 2 first counterclaims also lost their opt-out and considered that it was not called upon to give a decision on them. But also on the third claim, the court unanimously rejected it. This claim was related to that declaration that any request by Chile for those waters, including a possible compensation for that enhanced flow, was subject to an agreement between the parties. The court rejected it because it considered that it presented a hypothetical future scenario and not a real and current dispute between the parties. So that's a very brief summary of the decision of the court. And together with the judgment, 3 of the judges of the court also issued 2 declarations and 1 separate opinion. And they basically criticize that main decision of the court of declaring most of the claims without object, instead of issuing a declaratory judgment on those claims. Thank you.
Thank you, Laura. Thanks, everyone. As you can see, everyone, this is a very interesting decision by the court in the sense that it really didn't give or didn't make a lot of sort of substantive decisions. And I'd be very interested to hear from you, Mara and Gabriel, as sort of international water law experts. How do we deal with what do you think? One, from the sides of the arguments that were presented by the countries, what that means, and also you've both been referring to Article 11 and Article 12 of the Convention. Remind everyone again the nuance between these articles, and really I think that's where the decision was very interesting, and there was a lot of information provided by the court in relation to its earlier judgments. I'd be very curious to hear on how you reflect on the points of the court on these 2 articles, but also what do we make of this judgment where it's really which is missing declaratory judgments, which the court does in other cases. And I'll give it over to you first, Mara, and then Gabriel. Muted, Mara. You're muted.
Thank you. Sorry. Yeah, I think that from the point of view of Chile, it is very important that is a recognition of the international nature of the Silala River, because no, there was a changing in the position of Bolivia, and now it is clear in the judgment that this river has an international status, and it is submitted to customary international law, and also the fact that even if a river has specific features like the channelization, this does not mean that there are particular rules of customary law that it applies to the river. Even with or without the channelization, there are the same rules, in particular the principle of equitable and reasonable use that applies to this water course. And then I think also an important element of the judgment also related to the principle of equitable reasonable use, it is that we should not have a static view on the principle of equitable reasonable use, but we have to take into account the evolution, for example, of uses of a river. So not static, but an evolutive notion of equity. Then there is also the reminder of the community of interest that applies to a river. So here now we can see really how the jurisprudence of the court is constant in the different judgment, and of course the fact that Article 11 it is not recognized as a customary international law. For me, it is a little bit a deception. I should say, also because it is the exchange of technical data and information. It is really the first step for establishing cooperation between countries. But at the same time, I would like to remind that the court says that the parties have to bear in mind the need to conduct a consultation in a spirit of cooperation. declaration. So even if the court does not recognize the customary nature of Article 11, it says that countries must continue the conversation between them. So, and maybe just a short remark about the fact that there is no need to have here a declaratory judgment. There is a specific paragraph in the judgment where the court explains why the court decided not to include the agreement of the parties in the operative paragraphs. It has chosen to do so because there was a convergence in the views of the parties, and therefore there was no any more dispute. Thank you.
Thank you, Mara. Also one question that I have, and maybe Gabriel, you can also speak to that, is like, is the absence of the declaratory judgment of the court, for instance, on the nature of the water course, does that change anything in terms of international water law? Do we need these declaratory judgments, or do we live with what's in the decision, what's written in the decision, and what the court has sort of included in its judgment, even if it's not in the final decision, the operative part of the judgment?
Well, I do think that that is, a significant outcome of this particular case. And I want to highlight a couple of points. One, so to pick up on this issue of the absence of a real declaratory judgment, you have to think about what will parties now think about when they go to the court, and the possibilities that the court will come out with some kind of ruling that does not actually declare anything, because what it did is it really put the burden back on the two parties, and the court basically said, okay, you've converged on your positions, and therefore go back and deal with it and cooperate. And I'm not sure I'm not sure how helpful it is as a matter of law. As a matter of politics, maybe that's a different issue. And the idea that you're telling the parties that there's no legal issues here on almost any of these points that both sides have raised, and therefore you should go back and just discuss it amongst yourselves. I suppose that as a political matter, that can be a good encouragement to have parties negotiate and continue deliberations. But as a matter of law, I think some countries who are looking at this case will be questioning, well, what's the point of going to the court? So I think the court is putting itself in an awkward position of deciding that it won't decide on the matter. And I think I'm not sure how countries will be looking at it. I think as a legal matter, one of the most significant, that was one of the significant points. I think the second significant point is on the basically declaration that Article 11 is not part of customary international law. And the important point here is that Article 11 is it's not based on a threshold of harm. It talks about that the countries are supposed to consult and exchange information and so on the effects of on the possible effects of planned measures, but it's not giving us any kind of threshold of when does that have to be implemented? Is it when you have potential significant harm, or just possible effects? Well, we're not sure what possible effects. It's clearly possible effects is something lower than potential significant harm. And so the fact that now we do have to have that kind of potential threshold, which is in Article 12, I think that does actually provide some clarity to countries in terms of when do they actually have to start providing prior notification, and when do they have to exchange information. I think the points that Mara raised about channelization, I want to build on that a little further, because just take Europe, for example. I mean, the rivers are so heavily channelized and interconnected. And the question is, does that have any effect on international water law? And I think it's an interesting point that the court effectively, didn't really touch this issue. Yes, they recognize it's a law that was channelized, but they said that the whole basin is subject to international water law. So I'm not unclear whether that means that all channelized water bodies are still subject entirely to international water law, or that the court just didn't want to address these kinds of scenarios, and at least for the Salalah, said that the Salalah Basin, it's as just one example or one situation, that one is going to be all subject to international water law. So I think that's going to be something that we might want to think about in the future in terms of, you know, all these rivers that are interconnected. And it's not just Europe. There's we have it in India, we have it well, South Asia, we have it in other parts of the world, North America, and so on. Well, I want to point on one last part, which is much more of a political maybe spin of the cases, because I found it interesting that both parties, you know, declared victory after this case. And if you listen to the statements of the representatives of the governments, and of course this is probably to be expected, but Chile, and I think they both had some kind of basis to claim victory. Chile did succeed in getting Bolivia to recognize that the Salalah is an international watercourse, which I think is a pretty significant step. It also succeeded in arguing that because it's an international watercourse, therefore the watercourse is subject to equitable and reasonable utilization, which I think is also something Chile was really an important point for it. And I think as another matter, it achieved its goal in rejecting the possibility of compensation, or that compensation should be part of the decision. Now, of course, the way Bolivia worded its counterclaim is that any kind of maintenance of the infrastructure would have to be subject to negotiation that could include compensation. That's the way Bolivia worded its counterclaim, and the court rejected it as a hypothetical. So it didn't go to the substance of it, but I think Chile did win on the argument that compensation is not part of the decision and it's not part of the outcome of this case. Now, on Bolivia's side, I think that recognizing, you know, it had to recognize that the Salalah is an international watercourse, but for its side, it feels that it did have some measure of victory by saying that as a result, if it is an international watercourse, then also Bolivia has a right to equitable and reasonable utilization, which I don't think Chile was negating or arguing against. There's the question, though, of this artificial flow, and I think Bolivia was concerned about whether this additional flow or enhanced flow, as it called it, was part of the baseline that was now subject to equitable reasonable utilization. And in the context of the case, Chile did not claim any right to that additional enhancement. So I think for Bolivia's side, it did achieve that goal. I think two other points that Bolivia achieved. One was that the court effectively said that Bolivia did not violate any procedural norm of customary international water law. No, they did not violate the no harm provision, did not violate procedural, the notification provisions. On the no harm, there was, I think, convergence, but on the notification provision, the court rejected. That's the one of the ones that the court rejected in the case. And then finally, Bolivia, I think, was very pleased that the court recognized that it had sovereignty over the infrastructure that was located within Bolivia, and that effectively gave Bolivia the right to dismantle it, so long as it does so in conformity with international law. But it gave Bolivia the comfort to know that this artificial infrastructure was not something that was out of its control. It had sovereignty over that infrastructure. So I'll stop there, and we can move on.
Thank you, Gabriel. And I think on the last point on the infrastructure, I think there was also not really an objection from Chile. I guess that was sort of one of the points where there was convergence. Yep. As to your point on what does this decision leave other countries with? We're going to go into that in the next part of our session when Salman and Richard will discuss sort of the implications of the decision on international water law, but we have many questions coming in from participants, and I would like to pick up at least those. We can't put all of them in at the moment, but it would be great if you could respond to those that are directly related to the case. So there's one on how important the creek is in terms of yearly water amount crossing the border, and whether the two parties have ever discussed the issue directly through a third party or with an objective of reaching an agreement. There is another question whether the ICJ also interprets the principle of equitable and reasonable utilization in the judgment, and what if anything it said about it. And then there was one more which says, but wasn't the silence on the customary status of Article 2 of the UN Watercourses Convention a wise approach for the court, given the hydrology of the river basins and groundwaters vary? So those are sort of the specific questions related to the case. That would be great if you could pick them up. Maybe Mara, you want to start and pick those that you want to speak to, and then Gabriel respond. So we can start with the first one on the importance of the flow and whether the parties ever discussed through other means. Go ahead.
I think it was very interesting to see, especially thanks to the scientific reports, to see the connection between groundwater and surface water. And one of the issues that was discussed, it was also the impact of the channels on the flow of water at the surface and groundwater, and there were different views also on the impacts of these channels if they were removed, if the flow was reduced. And at least in my view, but maybe Gabriel can say more, it is that there was at the end an agreement that even with the removal of the channels, there would have been a reduction in the flow of the surface water, but that this reduction in the surface water would have been compensated with the flow of the water in the ground. So then, so it is very interesting also how the science has contributed to the agreement between the parties, because at the end also the scientific views converged, and it was also very interesting to see when the experts were questioned by the counterpart, and also they received 2 questions by the judges. So I think that through this procedure before the International Court of Justice, really science become a central element, and parties and also the general public can better understand what are the scientific implication of the case. Yeah. Thank you.
Thanks a lot, Mara. Gabriel, over to you. What's the amount of water that is crossing, and do you know whether the countries ever sort of discussed outside of the court to try to reach an agreement?
In this specific, whether the Chile and Bolivia had tried. So it's, in terms of the history, this goes back to the late 90s, early 2000s, that the two parties did try to get together and have some kind of agreement worked out in terms of how to allocate the waters of the Salala. And remember, this you saw from the pictures from Laura's presentation. It's not a large river. It's a fairly small amount of water, but it is the Atacama Desert, so all water is significant. And the parties did try to negotiate an allocation agreement for quite a number of years, and were never able to fully reach an agreement, in part because of Bolivia's belief at the time that the waters originated in Bolivia and are Bolivian waters, and that they are flowing artificially across the border. And so that part wasn't resolved until later on during the case. So because of these positions, I think the two parties were not able to reach an agreement throughout the 2000s, 2010s. Now, as far as the science before the court, I think this is actually a pretty important point here. I think Mara's comment about the science that was developed by the two parties, allowing them to reach a consensus or a convergent point, I think is pretty significant. The court emphasizes the fact that there's this convergence, but I don't think that they emphasize enough how important the science was leading up to that point. And I actually am a little disappointed that the court doesn't do more with the science in terms of identifying the characteristics of the river and using the science more so in its decision. And I think the court could have done so, which is interesting because this is one of the very few cases where the court actually requested that the scientists, the engineers, actually come into the court and that they be cross-examined by the other party. So we actually had the scientists, the researchers who were leading the science on both sides come to the court and sit in front of the judges, and where they were cross-examined by opposing counsel in a way to try to draw out the science and try to find any, of course, they're trying to find any mistakes or loopholes or problems, but it really is a way to try to develop the science as a basis for the decision. I think the court could have done a lot more in terms of using the science for the decision that it did issue. But I think it's incredibly important, as the court said, that it led to the convergence, and that is actually critical because, yes, you might want the court to have a decision, and I think it's problematic that they didn't have some kind of declaration at the end. But maybe it's even better for the parties to come, with a dispute, and then slowly, because of the science, reaching a consensus and seeing that there's not much that they have left to dispute, and that's really what happened in this case.
No, thank you, Gabriel and Mara, for really sort of highlighting this aspect of science and how it played out in the court and then the convergence, because in a way, it also underlines the importance of the provisions, even though the court didn't think they were customary law, but the importance of the provisions of regular data exchange and information exchange and of consultation on planned measures, even if they don't cause significant harm, because that's exactly sort of what brings countries and scientists together, being like there are rational solutions where the science can really help in many cases on transboundary water disputes. And I want to stop this part of our discussions now because we have many questions come in that I think Richard and Salman will be speaking to in terms of how this judgment, what does it really give to international water law more generally? And Salman, maybe you can also pick up the questions on the equitable and reasonable use, and then also on what that means more generally to countries going to the court. And everybody who has posted questions, we will try to pick them up after we have heard from Salman and Richard commenting on the decision from sort of a perspective of water lawyers that have not been part of the process. So Salman, over to you on what are the contributions of this decision to international water law more generally?
Thank you very much, Christina. If we look at the three uses of international water courses, navigation, non-navigation, and boundaries, we realize that the three of them have been adjudicated by the either Permanent Court of International Justice or the International Court of Justice, starting with the River Oder case in 1929, which dealt with navigation. Then the ICJ started with the boundaries cases, starting with the Kasakili Sududu case in Botswana, Namibia. and then going through a number of cases, reaching San Juan case now between Nicaragua and Costa Rica. And then on the non-navigation side, we have the 3 cases that was mentioned briefly by all the speakers, that the Gapchikovo-Nagumoras case, the pulp mills case, and now the Silala case. And my observation is, I would go further than Mara, and main observation is that the UN Water Courses Convention figured out very prominently in those 3 cases, and it figured out prominently, notwithstanding the fact that none of the 6 parties, Hungary, Slovakia in the first case, Argentina, Uruguay in the second case, and now Bolivia, Chile, Bolivia in the third case, none of them was a member of the UN Convention. Yet they invoked the convention. They tried to rely on certain provisions of the convention. I should add that Hungary later on joined the convention, but at the time the proceedings were before the ICJ. Hungary was not a member. So we see this debate with the UN Water Courses Convention between the parties themselves and the ICJ. And what interests me also about the ICJ stance on the UN Convention is that in the Gapchikovo case, which was decided in September 1997, 4 months after the convention was adopted, the court did refer to the convention. And at that time, the convention did not have a single party, not just a party, didn't have a single signatory. Yet the court referred to the convention extensively and dealt with it. So my point here is that the UN Water Courses Convention is really figuring out prominently in those cases. Particularly the issue of the equitable and reasonable utilization. I think the court has cemented equitable and reasonable utilization as the guiding principle of international water law. And this goes back to Gapchikovo, where it clearly relied on the PCIJ and also the convention. Interesting enough, in the PCIJ, it dealt with the issue of it reiterated the issue of perfect equality of all the riparians to the water course, and it dealt with specifically with the exclusion of any privileges for one of the parties. And so that was really the beginning of the recognition and wide recognition of the principle of equitable and reasonable utilization. In the pulp mills case, the case was mostly on the procedural issue of notification and the substantive issue of environmental damage. Yet still the court managed to refer to the equitable and reasonable utilization and to reiterate what it said in the Gapchikovo case. In the case of the Silala case, I think it went further than just referring to equitable utilization as a guiding principle. It went on to subordinate, in my view, the no harm obligation to the equitable utilization when it mentioned that there is a right of equitable and reasonable utilization, but there's an obligation, corresponding obligation that the riparian does not exceed their entitlement at the expense of depriving other riparians from their equitable and reasonable share. So I think the Gapchikovo case, there was no mention at all to no harm. Here, there is a mention to harm in a number of ways, in terms of acquired rights, and in terms of the not depriving others, which is basically in depriving other riparians, which is basically the harm rule. So I think now it's clearly that from those 3 cases that equitable and reasonable utilization is the cardinal principle of international water law. The issue of notification came earlier in the pulp mills case. Basically, that was the main issue under the Uruguay River Statute of 1975, and the court dealt with it extensively. But what I found interesting in that case is that it dealt with the statute, not in the customary international law, not with the convention. Here, it dealt with customary international law and the convention, and with Article 11. Not representing customary international law, and then putting a higher threshold for notification. The UN Convention speaks about significant adverse effect. The court said significant adverse effect is not enough. A more stringent threshold of risk of transboundary harm, the risk of significant transboundary harm. So as opposed to significant adverse effect. And I think this is read with the what was court said about Article 11, that it does not represent custom international law. I think it really raises questions in our mind. We talk about international water law as the law of cooperation. So how can we really put in effect this issue of cooperation if the exchange of data and information is not part of custom international law practice, and then there is a very high threshold for notification? I just want to conclude with 3 remarks. One remark with 3 parts. Reading those 3 decisions, I see the disinclination of the International Court of Justice to issue provisional measures. That happened in the pulp mills case, clearly. And then I see also the disinclination to issue declaratory judgment. Many have thought that after the 2 sides' views converged on most of the pending issues, that the court would issue a declaratory judgment, saying its views on the matter. But the court avoided all the way the issue of the declaratory judgment. And the 3rd observation is the court also, this inclination of the court to look beyond the current dispute, saying that any future dispute is a hypothetical case, and if a hypothetical case, I don't want to deal with it. I'll stop here. I hope I did not exceed my time. Christina.
No, thank you. You can always exceed your time because we love listen to you. And no, this was great, and also sort of a good segue into the question I had for Richard is sort of to really sort of ask, what does this decision mean, and also other decisions of the court? What does it mean for countries seeking a decision by the court on the legal situation, and a decision on a dispute or of an issue that used to be a dispute? What is your assessment in terms of the sort of the implications for the broader dispute settlement system of international water law?
Okay, thank you. So hello from Vancouver, Canada, which is having a very rare February snowstorm right now. And so my power has been going in and out. So if you lose me, don't take it personally. I'd like to thank my co-hosts and my distinguished colleagues for the chance to comment on this. There's already been considerable buzz on the internet and other places regarding the implications of this decision, which many say raise more questions than provide answers. I've been asked to be purposely provocative to spark some discussion. So here goes. One obvious starting point to answer your question, Christina, and springboarding off what Gabriel said earlier, is the separate opinion of ad hoc Judge Sima, who zeroed in on what he called the implications of this case. And I think I'll just briefly quote what he had to say, because I couldn't put it any better than he did in terms of articulating the position that this decision is problematic in many ways. He says, quote, "This brings me to my 3rd and final set of observations. States appearing before the court have a legitimate interest in seeking declaratory judgments that may ensure recognition of a situation at law once and for all and with binding force. In order to be binding, this recognition must be clothed in the operative part of the judgment, which alone is binding on the parties." He says, "I am troubled that the present judgment might be read as sending the signal that any position may be held, however untenable, so long as this position is abandoned at the 11th hour of the judicial proceedings. In this regard, I see a difference between a dispute that has disappeared because the parties genuinely have come to agree in the course of the proceedings, and a dispute that has been hollowed out by one party wishing to evade a declaratory judgment and the legal effects ensuing therefrom." So those are very hard-hitting words. He also tracks in his final paragraph, his final statement, to another point that Gabriel started to make, which is this. States do not institute proceedings before the World Court at the drop of a hat. The cases they bring to the court are usually of considerable importance legally and politically, and the volume of preparation and work involved is significant, sometimes enormous. Hundreds of professionals may be involved, technical or scientific experts may be mobilized. The court owes it to the parties to render well-reasoned judgments which settle their disputes with binding force, and where appropriate, offer them guidance on their rights and obligations. Reflecting on the court's deliberative process, the then president of the PCIJ, Max Huber, once compared the court's decisions to, quote, ships which are intended to be launched on the high seas of international criticism, unquote. And then his final statement, it is a pity that today the court chose to launch an empty vessel. So whether Judge Sima, who put it so forcefully, is correct, only time will tell. But in my view, there's a bigger issue here, and that's probably the role of international law and the court and dispute resolution generally in a time of climate crisis going forward. I can't help but think of the countries I've had the privilege of working with over the years, Afghanistan, for example, which was always intrigued by the possibility of going to the court or wondering what the role of law would be and so on and so forth, and what message this decision is sending to them. It could be the Judge Sima message. It could be, as others have pointed out, that we both declare victory and move on, sort of thing. I'm not sure. I do know, though, that water is increasingly likely to become a key driver in a growing number of disputes with significant consequences for national, regional, international peace and security. And I worry that what do you tell your clients? What do you tell countries that are contemplating going to the court? Is this the vehicle? Is the ICJ the right forum? Is there a more compelling need now, I would say, to develop alternative dispute resolution mechanisms? What's happened to mediation? Why weren't third parties involved? I know they were involved to some extent, but maybe this underscores the fact that the legal mechanisms alone are not sufficient to try to resolve these disputes. Many would suggest that a non-adversarial collaborative process using interest-based negotiations is a much more thoughtful and proactive way of reaching sustainable results. They might be right. Would it work in this case? I don't know. But I think that's an option that we need to consider. So with all those, I've done what the court's done. I've asked more questions than I've provided answers. But I think that sort of highlights the problematic nature of this decision and not coming to that. But whether that was purposeful and whether it's a good idea, I think the jury is out on that. So we'll have to see what happens next. But personally, I would like to see much more emphasis on the dispute resolution that is not adversarial in nature, and court by its very nature is adversarial in nature. So thank you.
It's great. No, thanks a lot, Richard, for asking all these questions, because now is the time to really open it up. And I would also ask the panelists to just raise a hand if you want to come in on points. We have a couple of questions that are also general international water law questions that have come in, and I hope we can address some of those as well. But back to your last point, Richard, one of the questions is, what are the mechanisms that can bring justice to and can bring agreements to upstream and downstream parties to have a fair utilization of water resources? If it's not the courts, what other mechanisms do we have out there? Salman, I know you raised your hand, so I'll hand it over first to you, and then anyone else who wants to come in, please just signal by raising your hand so we can have a organized discussion, as is virtually sometimes a little bit challenging. Go ahead, Salman.
Yeah, the question I want to raise is the follow-up to what Richard talked about the adversarial system and trying to resolve the dispute through mediation or through non-judicial manner. And my question relates to Silala and both to Mara and Gabriel. I thought after Bolivia conceded that the Silala River is an international river governed by international law, the other issues are really minor issues. This is the crux of the dispute. And once that issue was resolved, the other issues are too minor to really go to court. Have the lawyers of the two parties thought of sitting together and saying, look, the cardinal issue is gone, the basic issue is gone, we have minor issues, let us resolve them by negotiations ourselves on behalf of the two countries, and we can tell the two countries what we are doing, rather than going into this bitter process, lengthy, bitter and expensive process.
Great question. Gabriel, Mara, you're smiling. Who starts?
I'm not going to speak for Mara and her client, but I will just make the comment that, the lawyers are working for the client, and it's up to the client to make those kinds of decisions. And in some cases, they make decisions that make it difficult to do what Salman was just proposing. And so I'll leave it at that. It was not possible to do what Salman was suggesting.
That is a great insight. No, Gabriel, that's a great insight, because I mean, as you said, everybody has terms of references, and there's
it's more than that. This became highly political. And Laura, and I think Mara mentioned the whole history going back 150 years with the loss of access to the Pacific, and this was just another political issue that has really created a rift between the Chileans and Bolivians, and I think the relationship is so challenging that a simple solution is already a complicated situation, because you've got to get through all the other political issues to be able to sit down and have that kind of potential simple solution. And it was just politically, it was just not possible.
It's a great insight, right? Because, and Mara, I'll give it over to you in a second, but it's really sort of still the international legal system. We have the states in the driver's seat, and lawyers, scientists, we all have sort of our own solutions, but it's the states who are in the driver's seat who are the main actors. And
No,
Mara, sorry, Mara wanted to come in. Let's hear from
Christina,
her
can
first.
I just clarify my question?
Yeah. Go ahead.
I wasn't really asking the two groups of lawyers to act on behalf of the state. No. What I was saying is that they should have moved. Of course, they have to go to their clients. Why wouldn't they put their clients and say, look, the major issue, the cardinal issue has been resolved. We have other issues. Let us resolve it in an amicable manner, through mediation. And I wasn't at all suggesting that the lawyers would act on behalf of their clients or without their knowledge. No. And was that they should consult with their clients and sit together, perhaps the two parties with their lawyers, and resolve the issue through mediation, through discussion, negotiation, and mediation.
Thank you. Yeah, sorry, Mara first, and then Richard. Thanks.
Yes, no, I think that we all know that even though if the dispute it is a legal dispute, there is also a political component. No, in any legal dispute, especially at when international law is involved, there is of course a political dimension, and then there are also many different interests. And also, no, it is important to say that states are not clients as others. I mean, no, the state, as Christina said, it is not they have the sovereignty. No, that is a unique attribute of state. So there are many different sovereign interests that they have to protect. Yeah, thank you.
Thank you, Mara. Richard?
Well, I was going to say, full disclosure, I do work part-time for the excuse me, the United Nations Department of Political and Peacekeeping Affairs Mediation Support Unit. And I'll be the first to tell you, mediation is not a panacea for everything that ails the world and for every water dispute. But there's something to be said for, as I say, having a non-adversarial, a neutral person, and having a problem-solving, interest-based process. I've been involved in a lot of litigation involving water, and my experience, at least, is that it takes on a life of its own. That the whole litigation mentality takes on a life of its own. The cross-examining of witnesses and the search for truth often gets subsumed in wanting to win the case, whatever winning might be to anybody at any particular time. So I think there's a compelling case for mediation. I think mediators have a lot of work to do. I think the technical expertise that needs to back up mediation is not always there. I think people have an unfamiliarity with the process, and it's particularly tricky in developing countries where I think many people perceive mediation and all that goes with it as being a developed country thing, perhaps. And I think that there's just the general unfamiliarity with it. People don't usually accept anything till they've had actual experience of it. But I think there's a role and a niche there. And even now, in this case, I think there's a role and a niche for something like that to play a key role of bridging things. And then they can look at the bigger picture. They can look at the interests and so on and so forth, because I think that's what's necessary in order to move forward. What I'm pleased to see in this case, of course, is that the scientists, if they didn't collaborate, they certainly, you can do all the great science in the world, but unless your scientists and their scientists have some sort of common interest and understanding, you don't really get very far, right? And nobody has more experience with that than the World Bank.
Thank you for the shout out, but I think there's a lot of places, of course. I think that and as you said, Richard, sort of the transboundary water law area, it requires the collaboration of a lot of different technical experts. It's the lawyers, it's the scientists, but it's also, as everybody pointed out, a very political space. We have multiple conversations now going on the chat. We have questions on the Q&A. So I wanted to also come to one of the questions which was about, if we're not using judicial mechanisms, and Richard, you've pointed to some of it, what is out there? How useful are river basin organizations? What are sort of the other mechanisms that are being set up? And Gabriel, I saw you also responded already to a couple of questions on groundwater. Maybe let's speak also a little bit about how do we look at groundwater and international water law, and what are the mechanisms out there that are really sort of maybe yield more satisfying solutions to countries in terms of managing waters they share sustainably? Salman, I see you're not muted. I'm not sure whether you wanted to come in on this point, or
I will come later. Get some. I'll keep my. I want to hear some answer and then comment on that.
Okay. Who wants to speak to Mara? Maybe you want to speak to sort of other non-judicial mechanisms that we have available to resolve conflicts or even prevent conflicts.
Yeah, I think that in international water law, we have the river basin organizations that can play a very important role in the prevention or the settlement of disputes. So these are really not the first mechanism after bilateral negotiations that can play a role, of course, when they are there, because now in the case of the SILAR, of course, it was not the case. And in another case brought in the Palm Mills case, there was not the administrative commission of the Uruguay River that now it played a role trying not to settle the dispute, but at the end, no, it was not sufficient to sort this dispute. But I would say that the first mechanism out there to use when it is in place, it is a river basin commission, river basin organization. Thank you.
Thank you. Salman, yes, please come in, and then Laura.
I was hoping one point would be raised, but it hasn't been raised. I will raise it. Yes, Richard, I think the resolution through mediation or through non-judicial mediation, reconciliation, good use of good offices is really could be a very effective mechanism. Could be a very effective mechanism. We have the Indus Waters Treaty. The Indus Water Treaty was negotiated for 10 full years, and with so many difficult issues. And negotiations almost collapsed on the way many times. Yet I think the World Bank was quite successful and played a very positive role using its convening its influence, convening power, resources to get the agreement. There wasn't really, we tried, I was with the World Bank at that time, we tried to intervene in the Kasakil-Sududu dispute between Botswana and Namibia, trying to resolve it in an amicable manner outside the judicial process, but that didn't work. And I asked Christina to give a chance to someone because I thought someone may raise this issue. I wrote an article or a commentary actually sometimes ago calling for or suggesting a role for IWRA in international water disputes. And that was during the celebrations of the 50th anniversary of IWRA. And I was thinking to myself as I was following the proceedings of the Silala case, isn't really this is an excellent case, an excellent opportunity for IWRA to intervene and say, Gabriel, please get Bolivia to sit with us. Mara, please get Chile to sit with us. The four of us, the two of you each side, and with someone from IWRA, we can sit down together. We can put a team of hydrologists, lawyers, economists, dispute resolution. I mean, I say I'm talking about the IWRA. And I'm really want to raise this issue now, and nobody has an answer, but can IWRA play a role in those kind of disputes? And if the answer is yes, should it play that role?
That's a very good question. I want to give the word to Laura before maybe Gabriel, you want to speak also as a former president, immediate past president of IWRA, where you see the role of technical associations. But Laura, go ahead first. You had a comment you wanted to.
Yes, thank you. I just wanted to point out that even maybe the judgment didn't set much, the proceedings itself had been very, very useful, because before the proceedings, the two countries had very different positions. So it was the fact of having to react to that claim of Chile and so forth, that Bolivia carry out more scientific studies. So now the science is more clear for both parties on that area. And in fact, it was because of the proceedings that now we have a convergence between the position of the parties. So I think indirectly in this specific case, the proceedings really had that effect of approaching the parties indirectly, not because of the judgment itself, but because of having to go through those proceedings. So I think in that sense, they have been very useful.
That's an excellent point. Then I'll give it over to Gabriel, and then I will do concluding remarks and then hand it over back to Lindsay. For the panelists, there's still a couple of questions. If you have time to answer them in writing, please pick them up. But over to you, Gabriel. Where do you see the role of technical associations such as IWRA in the transboundary water dispute or cooperation setting?
Yeah, let me first say, I think one of the problems we have with these kinds of disputes is that the countries focus on the rights. My right to water, how much water I'm entitled to, what the allocation should be, or on things like significant harm. You've harmed my interests, my country, my territory, my sovereignty, and so on. And whenever you have a dispute of this type, it's going to be antagonistic. And I think that the more successful relationships where you don't have disputes that arise to the level of going to the court are the ones that focus on procedure. So where you have countries that focus on procedure in terms of data sharing, engaging with each other, prior notification, the procedural obligations of international water law, I think you see more scenarios where the countries actually either don't have disputes or resolve their disputes before they get out of hand and have to go to the court. When you start focusing on the substantive rights, equitable reasonable utilization, no harm, and so on, I think it creates a lot more challenges, because then you're talking about it's mine, it's yours, how do we allocate? And then you typically need to go to that third party. When you have disputes over procedure, I think it's much easier to resolve. So now to Salma's point about IWRA, as a technical professional membership association where it has a large body of scientists and they can develop data and evaluate data, I think there could be a role for something like this. But I think we have to be very careful that the association does, the association has its purpose, and that we don't shift that purpose to become a mediation organization. And I think this is a balance that has to be, the association itself has to decide. but it doesn't preclude the possibility that a country or two countries in dispute come to an association like IWRA and specifically ask, because of the expertise, can you help resolve dispute in this particular situation? So I'm not suggesting that IWRA should actively, open up its door and say that it's a mediating organization, but I think it can create the space if countries are interested for those kinds of that kind of support. So.
Thank you, Gabriel and Richard. Unfortunately, we have to close. I cannot give the word back to you, but I just wanted to thank all the panelists and also the participants for their questions that really sort of made this discussion so lively and rich. It's really it was very interesting to point out that, sometimes this court decision, in particular this one, can seemingly be very frustrating, and they kind of highlight that law is maybe not always the best way to address transboundary conflicts. I mean, that the whole issue of having the science within the procedure, as you pointed out, Laura, to lead to a convergence of opinion really also shows sort of the importance of mechanisms of dispute prevention that are not always based in the law, but can be in the science, can be through informal proceedings and in particular consultation and cooperation between countries that don't need to happen in treaty settings. But also have pointed out, and Gabriel, I think you were the last one to re-emphasize the point, is sort of the importance or sort of the role of frameworks which outline procedures for countries on how to engage that lead to a prevention of litigation and that might happen in the future. So it is the international water law agreements, both the global conventions, but also basin level agreements that outline these procedures that ultimately help countries overcome the politics that also occur around water. Because if we look at the Silala case, and several of you mentioned that there's a sort of a political impasse between the countries. But what the countries can refer back to is customary international law, and in other cases, countries can refer back to treaties, like Salman, you pointed to the Indus water treaties. When there is a political impact, law really has this very useful role of providing the dispute settlement mechanisms that can overcome or can help overcome political impasse. And then, for instance, in this case, lead to some convergence of the parties through the proceedings of the court proceedings, or otherwise have other very sort of specified procedures that help countries resolve disputes. So thanks everyone for the discussion. I do hand it back now to Lindsay for closure and final announcements from IWRA and other organizations. Thank you very much.
Thank you, Christina, and thank you all for joining our webinar today. This was a very lively discussion. We had nearly 23 questions answered, which might be a record. And for those who didn't get your questions answered, please feel free to email them to webinars@iwra.org, and I will try my best to forward them to our respective speakers. Again, that's webinars@iwra.org. I'll put that in the chat. We have some other announcements that I'd like to share. One is for our upcoming Congress. Today is the final deadline for call for abstracts, special sessions, and side events. All of these announcements are put in the chats with their appropriate links. Additionally, there is a call for abstracts for the Land for Flood conference. Again, the link is in the chat. On March 22nd, which is World Water Day, which is coming up very quickly, we'll be hosting another webinar. Please stay tuned onto our social media chats for more updates on this webinar. Additionally, there is a call for contributions for the Water International Special Issue on water management in basins of rivers, lakes, and aquifers. The link is also in the chat if you'd like more information there. Additionally, the International Association for Water Law will hold elections for executive committee in April, and anyone who is not a member of AIDA, which is one of our co-hosts of this webinar, is welcome to join and participate in these elections. You can find more on AIDA online on the link connected below. And once again, I just want to give a big thank you to each of our panelists for your time here. We had a really great and lively discussion. The chat was blowing up. We had multiple questions. So thank you for your time. And Christina, thank you so much for moderating today. And with that, I'd like to conclude our webinar. Thank you.
Thank you.
Thank you. Thank you.
Thank you. Bye.
Everyone.
Bye.
Thank you.
Bye-bye.
Bye, everyone.
Bye, you guys. Thank you.